To the attorneys on the jury trial, we're waiting a juror.
We're waiting on the
Okay,
jury.
thank you.
So, I mean, it doesn't matter, but just say Gary, Gary, whenever you.
Here we go. State versus James Cody Davis. Credit card fraud and a felon with a firearm. 2 charges, 2 big problems. Which one do you think will hit harder in sentencing?
Court is calling 2024 CR 012793. State versus James Cody Davis. Could I have parties announced?
Jason Gary, for the state, Your Honor.
I'll report for Mr. Davis.
And are you James Cody Davis?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Davis, did you review the true bill of indictment?
Notice this. Prosecutors just dropped half the charges. That might sound like a win for Davis, but don't get it twisted. The ones they kept still carry up to 20 years. Sometimes the state drops extras just to streamline the case, not out of kindness.
With your attorney, did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor. State is proceeding on count 1 and count 3, waiving count 2 and count 4.
This is the reality check moment. 2 to 20 years on one count, 2 to 10 on the other, and fines up to 10 grand. Judges spell it out so defendants can't later claim, "I didn't know how bad it was." Believe me, this part is airtight on purpose.
Any objection?
No objections.
Right.
And they're waiving the enhancements.
Or was there an error? Waiving the enhancement paragraph 2, Judge, just there.
Oh, there is. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
You're charged with fraudulent possession or use of credit or debit card. More than 10 items, but less than 50 items. And count 1. And in count 3, you're charged with.
And here it is, the big trade-off. By pleading, Davis gives up the right to a jury trial, cross-examination, and even the right to remain silent. Basically, he's folding his cards for a lighter sentence. Would you take the plea, or roll the dice with a jury?
Unlawful possession of a firearm by a felon. Count 1 is a second-degree felony. Range of punishment is anywhere from 2 to 20 years. Count 3 is a third-degree felony. Range of punishment is anywhere from 2 to 10 years in the prison. And both carry a maximum fine of $10,000. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you were giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Davis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on counts 1 and counts 3. Punishment is to be assessed at 3 years in the prison. There are no applications. The state will take in consideration 2025 CR 006038. Did you understand that to be the plea?
Yes, Your Honor.
Defensive, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Then to count one in the indictment, how do you plea?
No contest.
Count three in the indictment, how do you plea?
No contest, Your Honor.
Once the exhibits hit the record, it's game over. No jury needed. The judge locks in the guilty finding. From here on out, the only question is how much time Davis gets. Everything else is just sentencing cleanup.
State any evidence to support the defendant's plea.
Yes, Your Honor. State exhibit number 1 with all the attachments.
No objection.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations.
There it is, 3 years, concurrent, meaning he serves both sentences at the same time. Sounds lighter than it could have been, but don't forget, that felony conviction follows him forever. No guns, no appeals, and a permanent record. Do you think 3 years was fair?
Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And Deputy Lord, when you get a chance, they're bringing out Carrizales?
Yes.
Okay. I'll take Carrizales up after this.
Yes.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty of counts 1 and counts 2, and the court will find, counts 1 and counts 3, and the court will find you guilty. Are you proceeding with sentencing?
Please, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we respectfully request the court follow the agreement.
And state, is there any restitution that's owed?
Because I don't have the file, I don't know what Duffy would have that, so, it's a to-do office, so I think that we won't be asking for that.
All right. The court is going to order restitution if there's any restitution.
I don't believe there's going to be any judgment.
All right. The court is going to find you guilty of counts 1 and counts 3. Counts 1 and counts 3 will run concurrently. The court will sentence you to 3 years TDC and count 1, and 3 years TDC and count 3. This is both counts are to run concurrently. Taking consideration 2025 CR 006038, there's to be restitution, if any, and no contact with the following persons. And the court will give you credit for any time served. Is there anything else with regards to sentencing?
No, Judge. When it comes to the credit time served, I need to check in. I believe he was in jail on this, made bond, was back in jail, but it was still showing he was on bond for about 1 month during this time.
All right. If you'll confer with the clerks on that, we'll make sure he receives appropriate credit.
Thank you, Judge.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, you better do better, otherwise you're going to end up living in somebody's prison.
Oh, you would have.
I think so, but that's okay. If it's twice, you're good.
If it's twice.
Yes. All right, thank you.
Thank you.
Is that a thing, Mr. Davis?
Thank you for your patience to both my attorneys.
Oh, you're welcome. That's what we're here for. Lucian Carrizales.
But she's on her way up to that. I'm not sure that's her attorney. The defendant is right there. And the defendant is still there. I don't know. If you're on the legal strategy.
Yes, but he's not responding. All right, so we're just going to give you a contested date, and your attorney will have to make sure he makes that. All right, Ms. Ferguson, I need a date for contested hearing, please.
Judge, I'm present for.
Aye. You say you want a contested hearing?
Yeah, Judge, she didn't want to plead true to the violation, but I think we've got some explanations and it's a unique situation in which she never really started the probation. She was in custody when she pled and then was sentenced and then went off to TDC. And I'm trying to get some TDC records. I'm requesting them today. I don't know how long that's going to take.
All it takes is picking up the phone and calling TDC and see
That-
where it was.
Well, I've never done it before, but I went on their website. They have an email, so I'm sending them an email.
Mhm. All right, Ms. Ferguson, if you can set this in 2 weeks for a contested hearing. And then if you were in TDC, then we'll find out.
Yes, ma'am. I was also gonna speak for myself. As I was in TDC, I don't mind the probation. I would actually like to, because they wanted to revoke me.
Okay, so you'll have to discuss that with your attorney.
Okay.
August 7th, Judge.
So we're gonna bring you back on August 7th.
Okay. Perfect.
Thank you,
Yes.
Judge.
We do have confirmation that her parole was revoked and she was let out of TDC. There was a gap in reporting after her being out from TDC. So
There
that's
you go.
the,
So here's the thing, what I can tell everybody, if she's placed on probation and is revoked on her parole, if she's placed on probation and she's revoked on parole and sent to TDC, when she's released from TDC, she's supposed to report to probation. So we'll have a contested hearing on August 7th.
Thank you, Judge.
Thank you.
May I be excused?
Yes. Luis Alec Martinez.
Hold on, because they're putting both of the buildings up front. Yeah.
We will bring you all back today. Is there an application for this?
Yes, Your Honor. For deferred adjudication, it should be in there.
All right, the court is calling 2024 CR 6325, State versus Luis Alec Martinez. Could I have parties announced?
Jason Deerham.
Joseph Stateson for defendant.
And are you Luis Alec Martinez? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Martinez, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
State, are you proceeding on the indictment as presented?
Judge, again, this is not me that did that.
Your Honor,
The lead defense counsel statement.
do you have the written stipulations?
Yes.
May I,
Sorry, Judge.
Oh, no problem.
these are the admonishments. I'm sorry.
Oh, the stipulations?
Yes.
I'm sorry.
It's on the steps that one is crossed out.
Okay.
Will be everything except the very first paragraph.
Oh,
But it is 5 people. We're proceeding with 4 people.
A little bit unusual, Judge,
Because there are no counts.
Yeah.
listed.
and because they're all grouped together. So we're waiving, in the indictment, the state is waiving the first paragraph, or not, I guess we're abandoning it, that first paragraph.
That is our understanding. We have no objection. There was 5 people listed. The state's proceeding on only 4 of them.
All right. Did you review court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with theft, $30,000 to $150,000? I'm just trying to add up the amounts. Just give me a moment. Okay, we make it. All right. That's a state jail felony. Range of punishment is anywhere from 180 days to 2 years in the state jail facility and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you. You will be allowed to withdraw your plea. Do you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if your deferred adjudication were revoked for any reason, the court could sentence you up to 2 years in the state jail facility and up to a $10,000 fine?